Okay, Anders. Hi, everybody. Thank you for coming. This is an educational seminar. This is not a seminar where legal advice will be given. It is an educational seminar. Because it is an educational seminar, we are not calling this as a meeting. We are not calling it to order, nor will we be adjourning at the end. We'll just end it. So the purpose of this, and the reason we're having this year, after we held a similar one last year, is every year in town we have new members on our boards. Everyone deserves to have some background and learn about our open meeting laws, public records requests, and now, this year, our new amended ethics and conflicts of interest ordinance. So that's why we're having the meeting. We're going to structure it in a way that we have three attorneys here from the town attorney's office. We have Amanda Lafferty, Joe McLean, and Bob Fletcher. They will be presenting the legal aspects of open meeting, public records, and the conflict of interest ethics ordinance. And then we have Lee Suskin, who is the chairman of our ethics committee, and he will be providing a summary of the new amended ordinance for everyone. We wanted to structure this seminar in a way to hopefully captivate your interest. So we have 4 handouts. So some of you arrived early, and you might not have picked up all 4. They're right on the bench, right at the table right outside. So please make sure you get all 4 handouts. Also, we wanted to structure it in a way so real-life questions that you might be interested in having some guidance on could be responded to. So we have some hypothetical situations. For example, for emails, we're going to hopefully speak to what emails can you send, what emails can't you send? Where's the gray area in between? So with that, we are going to change, if you have an agenda, slight change of the order. The open meeting law will come first, followed by the public records request information. Then we will end with conflict of interest and the ethics ordinance. If you have questions after any of the segments, we'll have time for your questions after each segment. So with that, I'm going to turn it over to our attorneys who will lead us on the open meeting law presentation.
Now, Gary, are you going to talk about the items under?
Okay,
Gary?
We're going to talk about some minutes, agendas, rules of procedure. There are new rules for the open meeting laws that our state legislature enacted this past year, and they changed some of the requirements. People are concerned about posting minutes within the time frame set forth in the new legislation, which is 5 days. I put together a form last year to make it easy. It's really not hard. I put together a form. I gave it to Joe Colangelo, our new town manager. He adapted it a bit. If you are a chairman of any committee and you'd like any assistance and for some reason you don't have this form, give Joe a call. He will provide you the form, and it'll make your life a lot easier. There's certain things that need to be in those minutes, but it's not hard. Rules of procedure. We recommend that you adopt rules of procedure so you can deal with whatever might arise on your board. I believe our DRB, I know our DRB has rules of procedure, and I believe our Planning Commission has rules also. And the Select Board, of course, has rules. So, and agendas, there are rules having to do with posting of agendas. One of the things that has always concerned me is that when you post something on an agenda, please make sure people who read that item understand what that agenda item is truly about. Okay, with that,
Thanks, Gary.
you guys.
So, thanks everyone for having us. I'm Joe McLean. Gary, thanks for the introduction. What we hope to do here tonight is going to be similar to what we did last year, which is effectively have one person taking the lead in the presentation, but operating very much as a panel, and hopefully interacting with all of you throughout the presentation so that it's just not a dry recitation of you need to give these notices on these dates and make sure that you've posted in these locations. We're not going to read you the statute. We are going to follow this agenda, but we may move some things around as the discussion progresses. With that said, and just following up on some of Gary's introductory points on agendas and minutes, I want to point out that the open meeting law is a statute. It's not very long. Anyone can and should take the time to read through the statutory language. When you do that, you may find some interesting things. For example, the statutory requirements for what must be contained in meeting minutes are, as Gary observed, actually very limited. The statute only requires you to identify in your minutes the members of the public body that are present at a meeting, all other active participants in the meeting, motions, proposals, resolutions made, and the results of any votes with a record of the individual vote if a roll call vote is taken. That's it. You do not need to have meeting minutes that read like a transcript of the meeting. And so from the standpoint of what is required in order to get your meeting minutes posted, I know one of the new requirements now, and we'll talk about some factors related to email and electronic communications. One of the new requirements under the statute is that meeting minutes be posted to your website, if you maintain one, and the town does, within 5 days. And there was an initial panic of, oh my God, how are we going to do this? 5 days to get our meeting minutes out. But if you simplify the meeting minutes, and there's nothing to say that you can't have other notes of what occurred at the meeting, but in terms of meeting the statutory requirement, the meeting minutes really don't have to be that extensive. The other thing that I was going to point out has to do with meeting agendas and the requirements. Now you need to have posted the agenda 48 hours in advance of a regular meeting and 24 hours in advance of a special meeting. I don't know if there was there previously any time limit for posting the agenda of a regular meeting?
I don't believe so.
I believe there was. Now you have to know what you're going to talk about at your regular meeting at least 2 days in advance. Get it out there in the agenda. Again, the agenda does not have to be particularly detailed. So those were just a couple of points that I wanted to make and follow up to Gary's comments. And then in the spirit of not being overly redundant and giving the same presentation that we gave last year, what we really want to do is, and what I intend to do, is to talk a little bit in broad terms about the open meeting law and the concepts of what is and what is not a meeting, and what the exceptions, some of the exceptions to the open meeting law requirements, and then really focus on the new language in the law that deals with primarily electronic meetings, electronic communications, things of that nature. So, Title I, Vermont Statutes Annotated, Section 310 is where the open meeting law begins, and 312A of the statute recognizes a general right to attend public meetings and provides that all meetings of a public body are declared to be open to the public at all times. Well, in order to interpret and properly apply that language, it's necessary to first have a firm grasp of what constitutes a meeting under the statute. And it's worth noting that a number of important terms are actually defined right in the statute, including meeting. And a meeting is defined as a gathering of a quorum of the members of a public body for the purpose of discussing the business of the public body or for the purpose of taking action. And it's an open question in Vermont, precisely what constitutes a gathering of a quorum, and we'll talk about this in the context of email a little bit later. Also note that the gathering of the quorum needs to be for a specific purpose. And if there is a gathering of the members of a public body, but the gathering is not for the purpose anticipated by the statute, you don't have a meeting within the meaning of the open meeting law, or at least it's arguable that you do not have a meeting. Notably, new amendments to the open meeting law emphasize now what is not a meeting. New language that's been added to the statute now provides that a meeting shall not mean written correspondence or an electronic communication, which includes email, telephone, or teleconferencing between members of a public body for the purpose of scheduling a meeting, organizing an agenda, or distributing materials to discuss at a meeting, provided that those materials will be available for inspection and copying under the Public Records Act. So effectively, it is now permissible to use email, for example, even email circulated among a quorum of the members of the public body for non-substantive matters like scheduling. So if you, as the chair of the select board, send out an email to the other members of the board that says, I'd like to get the board together for a special meeting on next Thursday. Let me know if you're not available. Not a meeting within the meaning of the new definition of meeting under the open meeting law. Note, however, that care must be used to ensure that you don't go beyond those sort of routine, non-substantive scheduling meeting, matters or organizing agendas. It's one thing to ask, are members of the body available to meet to discuss a particular issue? It's certainly another thing to then go on and provide your substantive thoughts or ideas about that issue. And obviously, the closer you get to communicating the substantive business of the board to a quorum of the board, the more likely it is that a court could find that you had, in fact, conducted a meeting. Some other, along the same lines, some other points to make about what is and what is not a meeting. Bob will talk to you a little bit about the distinctions between the deliberations of a public body and executive session. One thing to note about deliberations of a public body: deliberations are of any public body in connection with a quasi-judicial proceeding are exempt from the requirements of the open meeting law. So, for example, if the Development Review Board conducts a hearing on a conditional use application, and at the close of the hearing determines that it wishes to deliberate, it can deliberate publicly or privately, but those deliberations are exempt from open meeting law requirements. Other examples of deliberations might include the caucusing of the Board of Civil Authority in a tax appeal, school boards and labor grievance appeals. When it comes to deliberations, I try to encourage boards not to use the term deliberative session, which is commonly used, and I think tends to confuse the exceptions to the open meeting law that are available to public bodies under the provisions dealing with executive session, with the right of a quasi-judicial board sitting in a effectively judicial capacity to privately deliberate, if it so chooses, on the matters that come before the board as a result of a quasi-judicial proceeding. Some other observations about open meeting law exceptions. The statute specifically accepts site inspections for the purpose of assessing damage or making tax assessments or abatements, clerical work or work assignments of staff or other personnel. And also, and this is sort of along the same lines as the exemption for non-substantive organizational matters, routine day-to-day administrative matters that do not require action by the public body may be conducted outside of a duly warned public meeting, provided no money is appropriated, expended, or encumbered. So, Dean?
Just was wondering, when would you like a question?
Yes.
Whenever you feel like raising your hand and I look at you.
Excuse me 1 second. Anyone who does have a question, we are being recorded. So please use one of the 3 microphones that are around the room.
So this would be a good time, Dean.
I wish I had thought to ask that a moment before I did. What I had written down is the exception that you mentioned having to do with what constitutes a meeting, is it interpreted as illuminating anything about what is a gathering of a public body, or is it just something that people look at the legislature as having said, no, when you're just organizing, it's not a public gathering? So I'm trying to, you said, or I think you said, that you'd be getting more into this issue of the electronic communications.
Yes.
So I'm just wondering, do people or attorneys look at that and say, oh, well, this is a marker and it would be generally interpreted as the outside edge of what would be considered the exemption, or is everything in play? So I'm just trying to get a handle on, because I think people have made their concerns known in the past about, when does an exchange of email that happens to finally reach the 7 members, let's say, of a 7-member board become the meeting? When is it a gathering? And does the exception illuminate what is the gathering at all? And if it doesn't, then where do you find clues about what's a gathering?
I think that, my view is that the concept of what is a gathering and the concept of the substance of the discussion are independent. They, to some extent, both inform whether or not you have an open meeting as a matter of law. I don't necessarily look at the legislature having identified certain non-substantive matters or certain matters that involve day-to-day administration as somehow informing the concept of what is a gathering. And the as far as I know, the only cases in which the Vermont Supreme Court has really delved into the concept of gathering a little bit is in this, I think, State versus Emergency Board decision from the early, I guess it was from the mid to late 70s, where The court at one point ruled that no meeting had occurred where attendance at the meeting had been by telephone conference call. And the court focused in its analysis on the need for both concurrence and physical presence to have a meeting. Now, subsequent to that decision, the law changed to allow participation in meetings by teleconference or audio conference. And as we'll discuss, there's now new statutory language that expressly authorizes new electronic participation in meetings and is very expansive in how it addresses that issue. In terms of what constitutes a gathering, the only reason I raise that as sort of an open question is there are some cases out of other jurisdictions where the court has looked at email exchange and whether and in what context an email exchange between a quorum of the members of a public body might constitute a gathering. Or the case that I'm thinking of was a case out of Virginia where emails were circulated among members of the board, and Virginia had language in its statute, its open meeting statute, that was similar to Vermont. It didn't use the term gathering, it used the term assemblage. And the court looked at whether or not there had been an assemblage of the public body as a result of these email communications. And I don't know if you would get this same result today. This is a decision from 10 or 11 years ago. But there the court looked and said that not dissimilar to what the Vermont Supreme Court had said back in the 80s, that basically they looked at whether there had been some kind of simultaneous coming together. And they said that, that was what was required in order to have an assemblage. And you could easily make the same argument that that's what's required in order to gather. You have to have some contemporaneous or near simultaneous coming together. There are circumstances where you can see email being used in a sequential way where it's analogous to the use of a letter, where that might not occur. You can also easily see email or chats occurring nearly simultaneously, or simultaneously to the point where not acknowledging that as a gathering of the quorum where the emails are discussing the substance of the business of the board would, it's very possible that would constitute a public meeting.
Hi, I need some clarification on the use of email.
Jeff, could you just identify yourself?
Yes, I'm Jeff Paulson with the DRB. So what I'm kind of getting from this is it's somewhat dangerous to use email other than for something administrative, to schedule when a meeting is and to collect information. But to have information come in, get circulated to a quorum of people, and render opinions, that's probably not a good thing to do. Is that kind of how I summarize that?
I think, you want to take this?
I think that's
right on.
generally accurate. Back a little bit to Dean's question, the reason the legislature has included the things you can do by email should give you pause about all the things they didn't tell you could do by email. And certainly if you're using email creatively or unintentionally to circumvent the public's right to participate in the meeting, then you run the risk of violating the statute. Now, that's a good general blanket statement in the context of a quasi-judicial body that is in the process of deliberating, where there is no requirement that there be a public meeting and no right to the public to participate. In that context, the exchange of substantive thoughts and ideas deliberate in a weighing of the evidence conceivably could occur electronically, because you're not at that point doing anything outside the scope of the open meeting law.
A follow-on question. Information that we get emailed to us through various members of the community or the town, and if it's of substance, should we direct that to go right to our agenda item for the next meeting? What's the way of handling that? It's not going to the public domain. It's coming right to us as members of a committee.
But it's,
And it's substantive. What do we do with that?
and you're talking about in your context as a DRB member.
Correct. Or in any committee.
Well, it makes a difference.
Okay, it's DRB member.
That's why I'm trying to distinguish.
DRB member.
Because lots of boards that are non-quasi-judicial will get lots of input from the public, and that you'd handle that in one way. If what you're getting is substantive input on matters pending before your body that are outside of the record, that's a completely different problem. I mean, that's potentially ex parte communications. It's potentially non-record evidence that you shouldn't pay any attention to.
Okay.
So, you know, I know I sound like a lawyer when
No.
I say this, but it depends.
Okay, so how do we handle it? We just direct it to go back to the next agenda item on the meeting so it can get presented in a public forum?
Again, if it's an attempt to influence the DRB in its decision-making and its deliberations, and it's outside of the context of the hearing that you've held, you shouldn't look at it at all.
Okay.
It's improper for the DRB to process that information. It would be just as if Lee were a Supreme Court justice, and I sent him, after my oral argument, I said, damn, I know, I'm going to send Lee an email that just points out, you know, Smith versus Jones. Can't do that. And the DRB shouldn't be, or any other quasi-judicial body or body sitting in a quasi-judicial forum, shouldn't be bombarded with emails on substantive matters. If somebody wants to put an item on your agenda and they say, you know, Mr. Chairman, would you please, that's fine. You can deal with that the next time you have a meeting.
Okay.
But if it's about, the application of Smith versus Jones, and you get it after the evidence is closed, doesn't matter the source of it, I would ignore it.
And just to jump in here, the ethics ordinance would require, first of all, let's assume you don't pass that ex parte communication on to any other board member, which you shouldn't because they don't need it, they can't use it. But when at the beginning of the next hearing, the ethics ordinance requires that you disclose that you got that ex parte communication, who you got it from, and what it said before there's any deliberation.
But it doesn't, Lee, I presume it doesn't require that you read the email. All it needs to say is, I received an email from Mrs. Smith on the subject of, and I read only the first 3 lines, and then I stopped.
I think you should disclose exactly what you did with it. If you didn't read it, you can say that.
Yeah.
If you did read it, you need to say what it said and who it came from.
It's important to differentiate, as Bob said, between matters that are being addressed by the Development Review Board, which, as far as I know, I could be missing something, but as far as I know, the Development Review Board only has authority to deal with matters that come before it in a quasi-judicial capacity. And when, in that context, the members of the Development Review Board are like judges, and they have to handle email communications and other communications that come to them in a manner similar to the manner in which a judge would. Now, there are other municipal bodies that act in administrative or legislative capacities. And so the open meeting law generally provides an opportunity for the public to comment during an open meeting, subject to reasonable rules established by the chair. So if in the context of addressing some legislative matter, say the Planning Commission is holding a meeting to look at possible bylaw amendments, and an email comes into one of the planning commission members, that email could simply be taken up as another piece of public comment and treated as public comment. That's a very different context than the context that the DRB is typically dealing in.
Sorry, I just wanted to jump in also on adding a little to the answer on Dean's question. It appears to me that they were trying to illuminate what constituted the business of a public body by saying certain things are not part of a meeting. Because obviously, if there's I think they were recognizing that by sending an email around saying, you know, do you want to meet next Thursday or the Thursday after that? I think they were understanding that that's a gathering. Whether you're all there right then getting the email or not. But I think they were trying to basically recognize that public bodies don't meet more than 2 or 3 times a month, and it's a lot easier if scheduling, organizing, or sending out packets of material just so that you're ready for your meeting don't constitute a meeting.
I'm going to jump in right now.
Yeah.
We wanted to ask some hypotheticals, so here's a follow-up hypothetical to something that you were talking about. When we have the email exchanges, you're allowed to have email exchanges amongst people on your board that would constitute a quorum for purposes of scheduling, setting an agenda, and for dissemination of information. So I want to try to lead us to that gray area in regard to scheduling. Let's say a select board member sends an email out saying, I'd like to add an agenda item to discuss the possibility of a municipal sales tax. Now, to me, that seems like it would be an absolutely fine thing to send in an email to the entire board. It's just for purposes of scheduling and identifying the item. What happens if she adds, I'd like to add a agenda item to discuss enacting a municipal sales tax because property taxes are too high? Is that now a discussion such that it would violate open meeting law?
In my opinion, no. But if the other 4 members of the select board all weigh in and say, express their opinions as to whether or not property taxes are too high or too low, now you're starting to have a substantive discussion
Well, that was my follow-up question. What if another board member responds,
well,
I don't want to add it to the agenda now or ever?
And if that
Tim Pudvar.
if that initial email goes out to all the board members, and I mean, there's another element to it, and that's timing. If that email goes out to all of the board members and there's a near immediate response, you're more likely to have a scenario where somebody could conclude that there was a gathering of a quorum to discuss the business of the board. If that email response comes in 12 hours later, and you really don't know whether whether a quorum even saw the substantive email or not, then I think, there's less possibility that you violated the act. It still concerns me, though, every time you edge closer to dealing with substantive matters electronically, just putting anything out there electronically, and we've said this before in terms of discussing email in general, but once you press that button, your control has virtually ended. And you need to be cognizant of that.
Okay, and here's a follow-up for letters. I get questions all the time from people. They receive an email from someone about some agenda item, and let's consider this a non-quasi-judicial situation. And someone talking to the Planning Commission about a possible amendment to a bylaw. And that Planning Commission member says, oh, I'm getting this. Everyone else on the board should see this email also. Can they just simply forward it to the other members without making any comment on it?
Yes.
Yes.
You can distribute materials to discuss at a meeting under the new amendments.
Now, hopefully, the forwarder will say, and there will be no discussion on this item until our next meeting.
Okay. Actually, that's something I often do on the select board, to remind people, please no discussion.
Yeah, and no reply alls and,
Okay, now here's something else, though. Let's say someone on the planning commission gets a letter, and they respond, or an email. They respond to that email.
Okay.
And it's their thoughts on the topic. It's not a quasi-judicial board. Should they copy, or may they copy, the other members on the planning commission or on design review or whatever the board is? Just for their information, that they sent it out to this person.
Well, again, being the lawyer, I'd say it all depends on what's in the email, but on the assumption that it's a matter of public discussion, and a particular member of the planning commission wants to express his or her opinion about it, he or she is not speaking for the board. He or she is replying as a member of the planning commission. I don't have a problem with that.
All right, thank you.
If this email is circulated and it's then discussed at a future meeting, would the email have to be included in either the minutes or the agenda or the minutes?
I don't think it's a bad practice at all, Lee, to take that email and either say we're going to append it to the minutes, or if it's not long, read the substance of it. Put it in the record. Particularly if if the planning commission in this case, or the select board in this case, is going to discuss the merits of what is raised there, how would you be able to do that without some context? How would you be able to have that conversation if you didn't know what the initiating communication was?
But I don't know if the open meeting law actually requires you to put it in the minutes. It's a question of what's a best practice versus what the statute requires.
So people understand with law and why these our attorneys here are citing to other cases is because there's very little case law in Vermont. So we look to other states to provide guidance to us. And the statute doesn't address every single situation. So they're using their experience and their knowledge on the topic to try to arrive at what they consider to be the probable course that a court would take should it ever reach a court. Is that fair to say?
Yep.
Yeah.
I'm trying to get you back here. All right, we have another question, if you don't mind.
No.
If everybody just please identify themselves when they speak.
It's facing the wrong way. Gail Henderson King. I just have a quick question. What constitutes a quorum if you've got a board that's supposed to be 7 members, you're down 2 members, so you only got 5 on your board? Is the quorum at that point 3 members, or is it 4 members?
The number of members hasn't been adjusted. It's just that you have vacancies.
We have 2 vacancies.
It's 4.
So it's
Quorum
still 4.
is 4.
So
It's a majority of the whole.
Okay. So technically, if we only have 3 members, we don't have a quorum, so we should not be doing any minutes or anything then for that meeting.
You don't have a meeting at that point, Gail,
Okay, thank you.
because you can't gather as a quorum.
That's a very good question. If we could follow up on voting for quorums, just because I get this question all the time from people on boards. If you have a 7-person board, you have 5 people at the meeting. What is it? How many votes do you need to pass something?
4. You have to have a majority of affirmative votes.
Right. Okay, we have another question.
Not to go in executive session.
Please use a microphone
Executive session is a majority.
and identify yourself.
I've got a question for you. You always trained me that if a DRB member gets an email about an application prior to hearing that the DRB members should send it off to the chair and to the other board members. Because the person sending it may think he's providing testimony, so I want to be careful about this. I don't think that a DRB member should just ignore it. He may respond and say, please send it on to planning and zoning, and I can't talk about it, but he shouldn't just ignore something that a member of the public is submitting to him pertaining to a hearing. Could you follow up on that? That's the way you always taught me.
So if it's pertaining to a hearing, as I mentioned before, there are.
And I would like to warn you here, if I might. This question might relate to a pending application currently before the DRB, and I want to make sure that the disclaimer that this does not constitute legal advice is fully understood by everyone in the room.
This does not constitute legal advice. I'll try to answer in very general terms, but in very general terms, quasi-judicial proceedings are different from other types of proceedings. In a quasi-judicial proceeding, only parties have a right to weigh in. So, for example, if you are on the DRB and you are reviewing an application for conditional use approval, the applicant is a party, and only those other persons who qualify as, quote, interested, end quote, persons under the statute have a right to then participate in the hearing before the quasi-judicial proceeding. So if in the course of that hearing, so if a hearing is opened and in the course of that hearing, a communication is sent to and received by a board member outside of the hearing by a person who if it's a person who is a party, it may be an ex parte communication. If it is, which you would then go through a process to disclose. If it is a communication from a person who is not a party to the quasi-judicial proceeding, you might acknowledge that this communication has been received, particularly, and you might disclose certain aspects of the communication depending on what it is, what it says, but I don't think that you're otherwise required to credit that communication or bring it forward in some manner to try to give it evidentiary status. I think it just, there's really no difference than the situation that Bob described earlier where someone sends an email to a Supreme Court justice outside of the context of a hearing. I'm not sure if I answered the question, Bill.
Well, and I'm looking at the rules, the DRB rules of procedure, and they define an ex parte communication as the direct or indirect communication between a member of an appropriate municipal panel and any party, party's representative, party's counsel, or any person interested in the outcome of any proceeding before the panel that occurs outside of a public proceeding and concerns the substance or merits of the proceeding. So this definition actually doesn't even include where just somebody who wants to throw out a comment sends an email to a DRB member. The definition of ex parte communication in these rules is limited to if someone who could participate in the hearing sent you an email outside of the hearing, or caught you at the grocery store and started bending your ear. But I would say that if just because it's someone who wouldn't have the right to participate in the hearing, I think then you would have to follow the ethics rules to disclose it without acknowledging it or pursuing it.
And again, this does not constitute legal advice, and there are more factors in this situation that has arisen as applied to real facts and circumstances before, because it includes people who have an interest in the outcome of that, and that is a whole entire other area of definition. We have timing issues, so if we could finish up with open meeting laws, that would be great.
Let me get to quickly the executive session as different from deliberations. Deliberations are the weighing and considering of evidence by the quasi-judicial body or a body sitting in a quasi-judicial proceeding. An executive session is a non-public portion of a public meeting. So it is a subset of an otherwise open meeting. And it is initiated only for, or can be initiated only for the specific purposes permitted under the statute. It can only be initiated upon motion by the body to actually go into an executive session. The motion has to specify the purpose for or purposes for going into an executive session, and they have to be among the 15 that are listed in the statute. And with respect to 6 of those 15, there is a finding that's required to the effect that premature public disclosure of the substance of the discussion to be had in executive session would be a substantial disadvantage either to the body or to an individual affected by that discussion. So, that's a lot to absorb. Let me give you the 6 that require substantial disadvantage or a finding of substantial disadvantage. And if you can't make that finding, if you can't secure a majority of those members present in favor of a motion with a substantial disadvantage finding in it, you cannot go into executive session to discuss the following 6 subjects. Confidential attorney-client communications made for the purpose of providing legal services to the public body. Contracts, labor relations agreements, grievances other than tax grievances, arbitration or mediation, and pending or probable, not possible, probable civil litigation to which the public body is a party. The other 9 are clear or imminent peril to public safety, a municipal security or emergency response plan or measures, discipline or dismissal action against a public officer or employee, the appointment or employment or evaluation of a public officer. However, the decision to employ that individual has to be made in public session. That can't be made in an executive session. Academic records of or suspension or discipline of students, not something you need to worry about. Testimony in a parole proceeding, hopefully also something you don't need to worry about. Information concerning a pharmaceutical rebate exempt from disclosure under federal law, probably something you don't need to worry about. The negotiating or securing of real estate purchase or lease options. This is the only subject upon which a public body can affirmatively take binding action in an executive session. The only thing that you can do in executive session of a binding nature is to negotiate and secure lease or purchase options. The other one that's the other reason to go in executive session is to consider records that are exempt from the Public Records Act.
What are the likelihood that any town board would enter executive session other than the select board?
Well, I mean, it's possible that a development review board or other quasi-judicial board might be in a situation in which the board could enter executive session, properly enter executive session to consider pending or probable litigation. It's not unheard of for parties or their attorneys to come before the DRB and in veiled or not so veiled ways threaten litigation if they don't get the result that they want. So
The other subject would be confidential attorney-client communications.
Right.
If that body wanted to receive our advice,
Well, or if our Natural Resources Committee, which is involved in our open space plans and makes recommendations for purchases of properties, could you see them entering into executive session?
it's possible to talk about.
But in general, the point I'm trying to get to, it's rare for any board other than the select board to have a reason to enter into executive session.
Most executive sessions involve the legislative body itself, the select board. The select board, a policy-making body. Select board's in charge, whether it wants to be or not, of all litigation involving the town. So,
Who calls the executive
Could,
session?
George, if you could just use your microphone, identify yourself as George Chavone.
Who calls the executive session? The chairman? Only the chairman, or can somebody in the audience call it? How does that start?
the body, a member of the body, George, would
member of the body.
would make the motion.
Okay.
And
then-
typically, typically, it's not a surprise. So it typically is on the agenda.
Okay.
Typically, the chair knows about it, and the chair is the one who makes the motion.
Okay, so
but it
then they
doesn't
go
have to
through,
be.
they have executive session on one of these subjects, get done with it, executive session's open, but there's certain things that are gonna happen because of that executive session, correct?
May or may not.
Well, if they may, how is that reported?
We take our vote once we come back into the public meeting and we approve it. For example, let's say we have an ongoing litigation and we enter into, our attorneys enter into a proposed settlement agreement. The select board is the body that approves that settlement agreement. We go into executive session because there's pending litigation, the disclosure of which would place the town at a substantial disadvantage. So we make that finding, we then move to enter executive session. We have the executive session, we discuss whether we want to enter into the settlement agreement pursuant to the terms offered. We don't vote in executive session whether to accept that agreement. We go back into open session, and then we have the vote, because that's the public aspect of it.
Fine, thank you.
I guess I'd just point out that I mentioned earlier that there had been some changes in the open meeting law. When we met a year ago, the statute was not crystal clear whether or not a public body could enter executive session solely for the purposes of receiving legal advice. That is now clear in the statute. Similarly, the statute now clearly states that with or without an attorney present, a public body can go into executive session to, subject to the preliminary findings, to discuss pending or probable civil litigation. That pending or probable language has been clarified in the statute.
Okay, so
Can we hit a couple quick things just to wrap up here? I had mentioned, and I won't spend a lot of time on this because it's not overly complicated, but I had mentioned the fact that it's possible to now, under the recent amendments to the open meeting law, participate in meetings through electronic or other means, and that can be done with any type of meeting, regular, special, or emergency meeting. Members participating electronically can fully participate in the meeting as long as they can hear and be heard. Each member participating electronically has to identify him or herself. If a quorum of or more of the members of the public body are going to participate in the meeting without being physically present, then there are some special requirements that the law includes, including that at least 24 hours in advance, the meeting be publicly announced and public notice be posted, and that the public announcement contain a designation of at least one physical location where members of the public can go and participate in the meeting And the statute provides that at least one member of the public body or at least one staff or designee of the public body shall be physically present at each designated meeting location. So theoretically, you could have a select board meeting with none of the select board members physically present and only the town manager in attendance. And as long as the technology was in place, you could conceivably conduct your electronic meeting that way.
Okay. You have something else on open meeting?
quick thing. Regarding the possibility of a joint meeting between more than two or more public bodies, each public body just needs to look at for itself what it's doing. Is it going to be during your regular meeting? If it is, then you don't have to do anything beyond what you would do for your normal regular meeting. And that's you have to post your agenda 48 hours in advance of your regular meeting, and the agenda has to include the joint meeting, as well as the topics that are the purpose for the joint meeting. If the meeting is, the joint meeting is not going to be during a regular meeting for your board that, or commission, for your public body, then it will be a special meeting. And then you need to take the steps necessary to warn a special meeting. So you both have to warn it as a special meeting, and then 24 hours in advance, you have to post your agenda as you normally would. And your agenda needs to include the joint meeting with the other public body as well as the topics to be discussed. And then for each public body, the chair of that public body would open the meeting for its public body, and the clerk for that public body would keep minutes for the public body. So essentially, you're each operating somewhat independently for your body. And then it's during the actual joint meeting that presumably there's been already some discussion about the topics and who's going to, basically what you're going to do during that meeting. But it is possible, it's just, it doesn't really matter that it's going with another public body. You just need to look at what your public body is doing and proceed accordingly.
Thanks, Amanda. We actually, the Select Board, starting last year, opened a new process of having more dialogues with every board, and we invite every board to come in during the course of the year and talk. So the Select Board is obviously, it's our regular meeting, but we give an opportunity for the chair of every board that appears before us to call their meeting to order and then to adjourn it at the end of that section of the Select Board meeting. So we're on top of that. So the next item for discussion is public records requests. This is a whole entire body of law. This could take an entire evening to discuss. We don't have time to do that. So this will be a truncated presentation, but it's something so that everyone knows what their obligations are in regard to public records requests. We received at least 2 of them last year, and I think 2 the year before, and they can be bothersome to people. They cost money. They cost the town money when somebody makes public records requests. But we have obligations, so and we want to comply with them. So our attorneys will give a truncated presentation on this topic.
I'll do it. So I get it. Well, first, I'll be quick on my piece. It's basically, we talked about this last year. Public record is very broadly defined in the statute as any written or recorded information, regardless of physical form or characteristics, which is, here's the key language, produced or acquired in the course of public agency business. So, emails. Your emails, whether they are whether they are part of an open meeting or not, are potentially public records. Your emails, again, in order to, even if let me back up, even if your emails are not public records, and are exempt from disclosure for some reason, they are potentially discoverable in the course of litigation. And as a general rule of thumb, I recommend that any email communications involving town business be treated as though they are going to be public records or are going to be potentially disclosed in a public forum at some point. So if you're dealing with town business, even if you don't like it, be professional in what you say, be somewhat circumspect in how you address that business in the context of the email, or you may be surprised someday to read your email on the front page of the Free Press. It's that simple. There are a few other minor points regarding public records in the context of quasi-judicial proceedings. I think most of you are aware that it is not necessary to come back into public session following a deliberation in order to announce your decision if the decision of the board will be a written decision and a public record. Similarly, it is permissible to, I believe this is still permissible, to enter executive session to review and discuss documents that are otherwise exempt as public records. And it is, in fact, permissible even in open session to review, to simply read a record that is an otherwise exempt public record. Without sharing it.
It's a little awkward.
Yes.
But it's been done.
I'll let you go on with anything else you have.
Yeah. So, as Gary indicated, Public Records Act requests are the new discovery tools that are being used in litigation. So, if the town or the bodies involved or potentially involved in litigation, construction contracts make for interesting reading, in particular, or are a source of Public Records Act requests. And they can literally cause the town's business in some respects to grind to a halt. You can't imagine how many emails you send are copied on, forward, and how many of those then are forwarded, copied, blind copied, sent forward, and so the implications for a small town under the Public Records Act can be enormous, especially in the context of litigation. And it involves not only your public email accounts, those that say townofshelburne.org or whatever, but perhaps your personal accounts. And you have a responsibility when you believe that your emails may be the subject of a request, either in litigation or not, to preserve those emails. And so if you purge your emails on the eve of the physical delivery of a Public Records Act request because you think there may be things in there that you don't want other people to read, let me tell you two truths. One is, if you know that that request is coming and you do it, the town's going to be in a lot of hot water. That's called spoliation of electronic evidence. That's the first thing. The second thing is all the people you sent those emails to or sent them to you, they haven't been purging their emails. So you'll stick out like a sore thumb as the only person who purged their emails and all of a sudden doesn't have anything in their inbox. Treat emails like they are your letters, like they're formal correspondence. They're not telephone calls. You want to be offhand with somebody, you want to put a little inflection in your message, call them up on the telephone. Don't send an email that says, how can you be that stupid? No one would ever think, fill in the blank. It's a recipe for disaster. We can get into the mechanics, Gary, of how you respond, but
You know, we have a lot to
Yeah.
cover with our new ordinance, so I'd like to turn now to our new amended Ethics and Conflict of Interest Ordinance. But apparently Tony has a question that she'd like to ask on public records.
hi, Tony.
How long should we hold on to emails?
There's no requirement that you hold on to them for any period of time, but if you're not going to hold on to them, you should try and be consistent about how often you call out old emails. So if you do it every 3 months, every 6 months, every 6 days, every 6 hours, whatever it is, you should be consistent about it so that you can honestly say to someone on the stand or in a deposition, that is my practice. I do it all the time. I do it the same way. I don't care where they come from. I don't keep that stuff.
You know, Bob, I can give you a little information. One of the
you.
things I plan to do is to, just like companies have document retention policies, discuss internally with the other select board members and with staff, seeing if we want to consider a municipal document retention policy, so everyone in town is on the same page. So that's something I plan to bring up at some point. So next we have our Ethics and Conflicts of Interest Ordinance. It was amended this past year. It was first passed in 2009. However, even though it called for the formation of an ethics committee, we didn't form one until approximately 2012. This past year, the Select Board asked that ethics committee to take a look at the 2009 ordinance and try to improve it. And they did that. We then, the Select Board conditionally passed it, subject to town vote. We had that town vote at town meeting so that people could have a better chance of understanding what they were voting upon. So we had a little summary of it and a couple of questions, and then we passed it. The purpose is to establish codes of conduct and guidance and to define and codify expectations and behavior for ethical behavior, and to ensure that our public officials are independent, impartial, and responsible, free from conflicts of interest, without personal or financial interest in any matter. We're also interested in fostering an environment where everyone is treated fairly and equally without special advantage, and as a result, we're trying to instill public confidence in the way this town government is run. So the way we're going to address the conflict of interest ordinance is Lee Suskin, our chair of the committee. I assume you're going to introduce all the members. And Lee will speak for not more than 15 minutes. Then we're going to have some questions, perhaps some hypotheticals, and we'll be looking to our attorneys to help respond to those so that the ethics committee is not put in the position of providing anything that might be considered an advisory opinion on an ethical matter. So, Lee Suskin.
I'm standing up and coming over here, partly so you might be able to see me, but partly to stretch my legs. We've been sitting for a while, and so I'm not going to force anybody to stand up and stretch, but anyone who wants to, I'll take a 30-second break. I encourage it. but not to leave the room. While you're standing up, I'll introduce our committee members. We've had a great committee who have worked very hard, meeting, 3-4 times a week for a year and a half to produce this document that is actually pretty legal and pretty hard to read, which is why we need this training session. But we worked hard. So my committee, the Ethics Committee, the Vice Chair is Tom Little, Pete Gadju, Bill Deming, and 2 of our members cannot make it tonight they wanted to be here, but for very good reasons. But anyway, Michael Ashew and Gwen Webster. Okay. The committee, it's a good thing we've been busy writing this ordinance because we have had nothing else to do for 5 years. No complaints have been filed against any public official in this town requiring the Ethics Committee to act, which is a good thing. So I congratulate all of you. And it says that we do have great public officials, great volunteers, great employees that are doing the right thing. And this ordinance is just to get in one place expectations so that continues and no one's going to inadvertently do the wrong thing, requiring a complaint. So Gary talked about what the purpose of the ordinance. I just want to add one thing before I launch. There was a comment earlier about I think the DRB or Planning Commission or many of the committees have rules of procedure, and one of them has a definition of ex parte communications. I'm not sure that that's exactly the same definition as the one in the ordinance, but the ordinance says that any procedure, rule, practice that does not conform with the definitions of the ethics ordinance prevails. So all committees need to look at your current rules and your current definitions and current practices, compare it to the ordinance, and make sure that there's no conflict. It's called the Ethics and Conflict of Interest Ordinance, but the ethics piece is really fairly small if you focus on just ethics, because there are certain activities of public officials that are prohibited. Those are using confidential or advanced information for personal or financial gain, unauthorized use of town property for personal convenience or profit, or soliciting or accepting gifts given to influence official action. Even if it's not to influence official action, the ordinance prohibits the acceptance of any gift of over $25 or a total of $100 in gifts in 1 year by any public official. The ordinance applies to all members of, I'm going to use CBCs, committees, boards, commissions. So most of the people in this room, not to town employees, not to Dean, but yes to Joe. It applies to the town manager, the town clerk, and the library director, and then all members of the CBCs. So committee activity, what are you doing when you're participating on a committee, which are most of the people in the room? Most of the committees are, I'll call them policy recommendation committees. They make policy recommendations to the select board. They're not quasi-judicial bodies that are conducting hearings. Although it seems in the room, we seem to have a lot of quasi-judicial body people in this room. In those cases, the members should always avoid conflicts of interest or appearances of conflict of interest. And the definitions of a conflict of interest are in the materials that I handed to you, that you picked up on your way in. Going to those materials, there are 3 sets of materials that you really need to care about. One is the ordinance itself, and the ordinance is the law. The ordinance is it. The other materials, the question and answer material, the shortened version that you have with you, the overview, those are just summaries of the ordinance. So in no way should the overview or the Q&A or anything I say substitute for a careful review and study of the ordinance itself. So particularly if any issues come up, that's what you refer to. So in the ordinance itself is the definition of a conflict of interest. Direct or indirect personal or financial interest of the public official, his or her spouse, or persons related within 4th degree of consanguinity. And so most of you don't know what that is, because I don't. But the definition is here in the ordinance, and it's on the Q&A, and it's on that other material I handed you. So that's, how far do you go with uncles or nieces or grandchildren to the point where you've got to worry about, are you taking an action that's going to benefit them as well as yourself. It also deals with business associates, and business associates are specifically defined here, and those are issues that often could arise, and you need to be careful if you're on a body, and even though it won't personally, you're not going to get personal or financial gain from any decision you make, will a business associate of yours gain? So look at that definition of business associate. I'm not going to read it right now. You have it in front of you. But that's where you have potential problems where people are not considering whether there's a conflict. This ordinance also applies if there's an appearance of a conflict. And the definition of appearance is simple. It exists when a reasonable person might have the impression that a public official's judgment might be significantly influenced by outside interests, even there's no actual conflict of interest. So you've got to consider that. Might that arise? And we won't get into any scenarios now. So what actions are prohibited? The use of confidential information or advance information obtained by virtue of public office. And other actions here. Well, we talked about that. I'm sorry. I switched my sheet. Okay. So what happens? What if there is an actual or apparent conflict? This is the non-quasi judicial bodies. At the beginning of the meeting, if you have an actual or apparent conflict, you must disclose it at the beginning of the meeting. After you disclose it, even if it's an actual conflict, you may participate if you make a public statement that you can act fairly and objectively and in the public interest despite the conflict. After disclosure, the other committee members may look at you and say, how do you think you can act fairly based on that? And they can ask you to recuse. But still, it's up to you. You're not required to recuse if you're in a policy-setting body, even if you have a conflict or an apparent conflict of interest. If you do recuse, there are specific steps that you've got to take here. You've got to make a brief statement of why you're recusing. You've got then to refrain from influencing any public official involved in the matter. You've got to leave the room. You may submit a written statement on the matter because you still have an interest in the result. Everyone knows you have a conflict, but still you're entitled to let the committee know how you feel about it. But it has to be written, and otherwise you can only participate in the matter through a representative. And after the matter, after that meeting ends, you can't talk to another committee member, a town official, or anyone else to try to influence the end result. Quasi-judicial activities are a whole different ballgame, and we've heard that with throughout this session. Those, it's like court. It's like judges. Think of how judges react if you watch The Good Wife or whatever TV show you're watching these days. Think of how those judges are acting, or should be acting anyway. And that's you. So that's the DRB, the Board of Civil Authority, the Ethics Committee, and at times the Select Board acts in a quasi-judicial body. I don't know if we have any others. But those are hearings. You're deciding, determining the rights of individuals based on the law, based on the evidence presented to you at the hearing, and based on nothing else. So in those cases, it's a little more stringent. At the beginning of each matter, the chair has to proactively ask each member of that committee whether they have an actual conflict, an apparent conflict, whether there have been any ex parte communications. And if so, you've got to disclose them. If there's an actual conflict, you're out. You've got to recuse. If there's an apparent conflict, or if you have made a prior public statement that indicates how you might rule on this matter, then you must disclose that, and it must go into the minutes. And but then in those cases, if you state that despite the prior statement, that despite the apparent conflict, I can act fairly, you can still sit. The chair and other members then, again, may say, what are you talking about? And may ask for more information to bring out, well, how bad is this apparent conflict, or how bad was that prior statement? The prior statement might be a judge saying anyone who convicts sexual assault should be sent to jail for 100 years. Should that judge be able to sentence someone who comes before them? So that's what we mean by a prior statement, indicating a prejudgment of the matter. If there's been a ex parte communication, you can still participate as long as you disclose it and it goes into the minutes of what that ex parte communication was, who it came from, and the substance of it if you read it, as we talked about earlier. If you're a member of a committee, CBC, you cannot represent anyone else before that CBC. You're a member of the committee, you might have more influence. So that's prohibited. If you recuse, you have to take the same five steps that someone disqualified from a regular committee would have to take. So that's essentially the process. Hopefully, no complaints will ever be filed. If a complaint is filed, the ordinance encourages people to first communicate their concern with the chair of the select board, who will try to resolve the matter to the satisfaction of the complainant and to the person who it's complained about. But at any time, a person can file a complaint with a clerk of the committee, who's now the town clerk. If the ethics committee gets a complaint, it'll investigate it confidentially. If no probable cause is found that the public official did anything wrong, the file gets sealed and it'll never become public. But if probable cause is found, a hearing is held. The ethics committee will conduct a hearing in accordance with the ordinance and then make a decision. The ethics committee could censure the public official, and if necessary, the select board could go to court to impact the decision made by the body in which the public official inappropriately participated. That's it in a nutshell.
All right, thank you very much, Lee. We have a couple of quick hypos, and we welcome questions on this. For example, on the DRB, is it permissible for a developer to sit on that board?
Yeah, that's
Yeah.
for you.
Oh, that's for us. Yes,
Yes.
it is permissible.
Right.
Under
So
this
then,
town's charter, the select board can appoint any qualified person to the DRB.
right. So then a salaried employee of a developer would also be a permissible member of that board. Right?
I believe so.
Okay. If anyone has any situations that they'd like for guidance, not legal advice, just guidance, please let us know. Let's say a planning commission member lives on a road where development is planned on adjacent land. That planning commission member doesn't want the development to go in for personal reasons. May the planning commission member participate in planning commission discussions regarding proposed zoning or sewer changes that would impact whether that development goes forward?
Do you like this one, Mr. Fletcher? Sure.
Yes.
Yes?
Yes.
Yes. Could you?
I'm only obligated to give guidance, Tom, not explanations. In my opinion, the planning commission is a planning body. It's a legislative body, and those folks come just like the legislature does, with lots of different backgrounds, lots of different opinions, lots of different perspectives. That's the beauty of the legislative process. And if someone happens to wish that land remained open and undeveloped and others wish that it remained developed, that's the source of which good decisions should be made. Does that help?
Now,
Would that person have to make a public statement under the ordinance?
I don't, there's nothing for the planning commission to do that would affect a binding decision on the use of that property for a particular purpose. Correct?
Well, if they're considering a
Look
zoning
at
amendment,
the ordinance.
But
Is that an appearance of a conflict of interest?
I don't think it is. No.
Okay, that's the question.
Because, again, the planning commission is only planning, not only. I didn't mean that the way it sounded.
this
Planning commission is making a legislative decision about how the town will be developed. They're not sitting in judgment of a particular project. They're not having to pass on the merits of, does this meet the zoning or doesn't it meet the zoning? Does it meet our bylaws? Does it not? They are simply saying, we think in this district, our R4 development is a good idea, or we think open space is a good idea, or we think mixed-use housing is a good idea. And in that respect, I think that it's not an appearance of a conflict of interest that someone has in mind how they would like to see their road developed.
And I question whether it would qualify as a conflict of interest under the ethics ordinance. It's, if that person, the public official, has a personal interest in the outcome no greater than that of other persons generally affected by the decision, such as adopting a bylaw.
One final comment, just in response to Lee's question. If you look at the ordinance, the definition of appearance of a conflict of interest is worded in a particularly broad manner. Intentionally so, I believe, to try to capture a broad range of possible scenarios. But there is critical language in here that cannot be ignored. The broad language references the impression that a reasonable person might have. So presumably you're applying an objective standard. But in my mind, the next clause is critical. After full disclosure of the facts. And so I don't look at that necessarily as requiring a public disclosure, but in order to have in order for there to be disqualification based on the appearance of a conflict, you need to have that those facts in front of you. I guess I'm inclined, just based on what we know from the hypothetical, to agree that you do not have a conflict at this time, given the legislative role of the Planning Commission. But one thing I want to emphasize about the conflict of interest ordinance and conflicts of interest analysis generally is that it is absolutely highly fact-driven. And so you cannot make generalizations based on limited facts about whether or not something qualifies as a conflict or the appearance of a conflict. And you may have scenarios where reasonable minds may disagree. As a matter of fact, in reviewing some of the case law on conflicts, what I found was that in several instances in which the court ultimately determined that there was a conflict of interest for one reason or another, very often the public official had first gone to their town attorney or some other person who supposedly has knowledge of how these things work and had received an opinion that, no, I don't see a conflict. You may proceed. And then they proceed, and lo and behold, ultimately down the road, a court decides that there's a conflict. So there may be a message there that it is wise to proceed conservatively and when it comes to things like this, but
just to be clear, the ordinance does not require either on a planning commission or a DRB that anyone with an appearance disqualified. Right. The question is whether, in this situation, would it be wise to disclose? I live next door to where the sewer line is coming, but I still think I can be fair and then participate. And this is not legal, and I don't think it'll ever come to the ethics committee, but I think it's probably good form. Why not? To just get that out there and then go forward.
Does anyone have any questions that they'd like to pose on the conflict of interest ordinance, ethics ordinance? What happens if a DRB member takes a position on an item on, let's say they post, we have a lot of people in our town, we have great volunteers here, but many of them are not hesitant to post on Front Porch Forum or send a letter to the Shelburne News. Let's say they do that, and then the item on which they spoke their opinion, there's an application before the DRB on that item. Should they recuse themselves then?
Well,
Or is disclosure enough?
So one of the important distinctions between boards that serve in a legislative capacity and boards that serve in a quasi-judicial capacity is that quasi-judicial bodies need to be concerned about the issue of bias, and they need to be concerned that they or mindful of their duty, particularly, I think, under the ordinance, to be impartial. And I mean, the ordinance has some affirmative language that applies to all public officials regarding fairness and impartiality, but I think it applies particularly to those bodies or board members that have to serve on quasi-judicial boards, like the DRB. I think it's noteworthy that the ordinance discusses ethics and conflict of interest. It doesn't necessarily go far in sort of prescribing what I'll call rules of judicial conduct. It doesn't necessarily dictate how DRB members should act. As a matter of just general practice, is it prudent for DRB members to widely expound on issues of policy that that may ultimately turn into a concrete application that comes before the board? Probably not. It may set the stage for problems down the road. I mean, we know from the experience that St. Albans had with the Walmart that making public statements in one capacity as a select board member and then sitting on the DRB when the same application comes before you may, combined with other factors, result in your actions being deemed invalid at the environmental court level. But with that said, the Vermont Supreme Court has also observed that not every statement of public policy by a public statement regarding a matter of policy by a public official, even if that official later serves in a quasi-judicial capacity, is going to result in a constitutional or due process violation. The court's gone so far as to say you really need to create a situation where, as the court put it, due process is only violated where municipal decision makers display deep-seated antagonism that would make fair judgment impossible and basically offend the rudiments of fair play. So you walk a fine line as a member of a quasi-judicial board when you make public statements, and each one, again, has to be evaluated on its facts.
And that's what I was going to emphasize, that I think it depends what the statements are. If, if it's a broad statement, this area of town shouldn't be developed with single-family dwellings or something like that. But if you're getting down to, if this piece of property is ever developed with such and such, I would never approve that. That's pretty clear that you're prejudging an application. And I think if you are unable, I mean, even without this ethics ordinance, if as a member of a quasi-judicial body, you are unable to review an application in an impartial manner, you shouldn't sit and consider that application. The court, the environmental division has not, of the Superior Court, has not been, except in the rare cases, if there's a de novo review in general, the court has considered, well, that's good enough, that'll undo, you get to a new hearing on your application. But, and even in the Walmart case, but there, you had someone who harangued someone who, well, several groups that obtained interested person status. So and in another case, they had someone who, in the other direction, who he wasn't opposed to the project. In fact, he had a hat that said, go applicant. So, either way, you can't, in either way, whether you're in support of an application or against it, if you cannot sit on it and review the facts of the application and apply the regulations to those facts in an impartial manner, then you should not sit on the board to hear that application.
What do you think about the situation when there's a pending application before the DRB? You spoke a bit about this earlier, just follow it up. Pending application before the DRB, should a member of the Select Board or a member of the Planning Commission send a letter to the DRB while that application is pending, advocating for the application to be granted or denied?
I'll go first. The Select Board, depending on the scenario, the Select Board may qualify under the statute as an interested person, and therefore having, assuming that the necessary formalities are followed, the Select Board could conceivably appear through a representative.
What about a Planning Commission member sending a letter or an email advocating one way or the other?
I mean, again, we discussed this a little bit earlier. If the planning commissioner, if we're talking about DRB proceedings, again, if the planning commissioner does not qualify as an interested person under the statute, then they have no right to participate in the hearing, and
The
so
DRB has no responsibility to consider it. It's not evidence.
correct.
All right, thank you. I hope someone else has a question.
Gary, if I could
Oh,
just
please, Joe.
point out a couple of things. I just wanted to make some general observations about the conflict of interest and ethics ordinance and about conflict of interest law in particular. You'll notice in the ordinance on page 2, there is a definition of conflict of interest that describes a conflict of interest as a direct or indirect personal or financial interest of a public official, and goes on from there. And you might find yourself wondering what those categories of interest mean. And you could search case law in Vermont for some feedback on this, and you might find a little bit of guidance, but there really isn't, as far as I know, a single place in the law that defines these different categories. Other states, Gary mentioned that as lawyers we often will look to other states for guidance, and other states have developed these concepts, however, and so I thought I would just very briefly review what these terms mean, or at least how they've been interpreted in other jurisdictions. So the town's definition of conflict of interest includes a direct financial interest, and direct financial or pecuniary interests are generally those interests that arise when an official votes on a matter benefiting the official's own property or affording some direct financial gain to the official. And I should also note that we've talked about recusal and disqualification. So recusal is basically the process by which a public official is disqualified from voting or taking action on a matter because of a conflict or the appearance of a conflict. And these categories that we're discussing here are basically the distilled circumstances under which disqualification typically occurs. So the first, as I mentioned, is direct pecuniary interest or direct financial interest. The second is indirect financial or pecuniary interest. And generally this arises when an official votes on a matter that financially benefits someone who's closely tied to the official, such as an employer or a family member. Are there other examples of indirect pecuniary interest that any of you can think of? The direct personal interest is one that often arises in the case law. That is a situation in which an official votes on a matter that benefits a blood relative or close friend in a non-financial way, but in a matter of great importance. And you see examples of this in the case law, the cases involving family members. And it's interesting because the action by a public official in a matter that somehow impacts a family member or which a family member is involved, at least, as a general matter, doesn't always result in per se disqualification. And the courts do look on occasion, for example, in a case where, say, a zoning board member votes to grant site plan approval to a hospital that wants to build a parking garage where his wife works. And opponents come forward and they claim that there was a conflict of interest because this board member's wife worked at the hospital. And the court there focused on factors like, how long had the wife worked there? What was her role there? How frequently did she work? And they ultimately, after looking at the facts again, concluded that the wife's employment was just too remote and attenuated to qualify as a disqualifying conflict of interest in that situation. Now, compare that with another case where applicant comes before the board. I think it was to build an A&P supermarket. And the board member's mother just happened to own a lot within 50 feet of the site where this supermarket was proposed to be located. And again, it was one of those situations where the board member went out and he actually sought multiple opinions regarding whether or not he had a conflict and was presumably informed no. And ultimately, the challenge resulted in the fairly, I think, obvious conclusion that, there was a close enough familial relationship and a significant, the court actually looked and said there really is some potential for indirect financial benefit here. And so the result of the vote was disqualified and they had to come back and do it again without that member. Another situation, again, you wouldn't think it would be a matter that would give rise to litigation, but new select board member has a husband who has been on the planning commission or planning board for 15 years, and he's up for reappointment, and the board is split, and she's in the position of having to cast the deciding vote. Guess what she voted for? She put her husband back on the board, and ultimately the court determined that that was not permissible given the nature of the relationship. The last sort of category of potentially disqualifying interests is an interesting one, and it is the indirect personal interest. And the way that the courts have looked at this category is that they generally look at it as presenting in scenarios where an official votes on a matter where the individual's judgment may be affected because of membership in some organization and desire to help that organization further its policies. And a common example that I've seen given is select board member also serves in the leadership of the local volunteer fire department. And the fire department receives funding from the town, and the fire department wants to purchase a new expensive piece of equipment. The scenario at least gives rise to a concern, if not an actual conflict, that that board member's loyalty may be divided and may give, and as a result, courts have looked at potential disqualification in situations like that.
And we have that situation in town, and our select board member who has that situation is already indicated he's going to recuse himself from
It's a common, as I understand it, it's a common issue that arises. Any questions about any of that?
Tom Little, please use the phone and tell everyone you're Tom Little.
Well, the question is, going forward, if members of regular commissions and boards or quasi-judicial commissions and boards, either as a group on the board or individually have a question about the ordinance, what it means in their particular situation, I'm not sure that anything has been laid down in black and white as to what the guidance should be, but is the select board or the town manager thinking about a way to provide some, reasonable guidance for people so that they don't, step the wrong way?
That's a good question, Tom. Well, I'll let you know that I get calls virtually every single week. People call me as chair of the select board, and I'm sure they called Tim before, and they say, this person on the DRB needs to recuse himself on this matter because he's got a conflict, or this person on the planning commission needs to recuse himself because he has a conflict. And there's a lot of gray areas, as we've heard discussed tonight. It's often not black and white, whether someone needs to recuse himself. We now have a conflict of interest and ethics ordinance that provides for certain disclosures. We're doing things on our website where we're including a little summary background of every person on every board, so people in town can learn for themselves whether there's an appearance of a conflict of interest for that person. So we're doing what we can. I field these calls on a regular basis. If someone believes there is a conflict of interest, we have a process now where it's addressed. When we pass this ordinance, one of the keys for us is we're a town of volunteers. We have great people in our town serving as volunteers. If someone could file a complaint with no basis saying someone is being unethical, and that was just reported out, someone could do a Google search and it would pop right up. Joe Smith accused of unethical behavior. And that person would be tarnished for life. So we wanted to provide a balance to address when there is a conflict, when there is an ethical issue, and to protect our volunteers. So we put these steps in for the initial complaints to go to the chair of the select board to do an informal investigation. And then if resolution is not reached to a satisfactory level for the complainant, it then goes to the ethics committee. And the ethics committee first conducts its informal investigation, and only if they find probable cause does it go forward. In the 6 years that the ethics ordinance, or 5 years that the ethics ordinance has been in place, we've never reached that stage. And I hope, frankly, we never do reach that stage. But now we have a process in place in case there is a legitimate claim of an impropriety that it can be addressed. So that's the reasons behind it. I try to answer the questions when they come to me, and there's now a process. If the person is not satisfied with the answer, they can go to the next, they can file a complaint.
But I'm thinking also about members of boards and commissions who are struggling with what they should do under the ordinance. Is there anywhere they can go?
Well, so far they've been coming to me. Dean, you want to?
Maybe I can ask a question that relates to Tom's question. Just to repeat, maybe I can ask a question that goes to Tom's question. We have the ordinance. We have quasi-judicial bodies like the DRB that function under the Administrative Procedures Act, which I believe makes them have to operate under rules of procedure that they adopt. Now, with the enactment of the ordinance, I was imagining groups like and I may have that specific detail of where the requirement or the authority to adopt the rules comes from, Joe, but they have authority to adopt rules, and they have rules. My thought was that one reason that bodies have rules is that they can answer some of these questions about how bodies will act. How should they behave? Now that we have an ordinance and the ordinance controls, there's the potential for a conflict. So when the body of the voters of the town adopted the ordinance, I was foreseeing a day when the DRB and other committees that had rules excised a lot of material and said, see ordinance. And so my general question is whether or not in a situation like this, would your recommendation be that they do so, or is there does there remain any role or room within rules of procedure for a body to create some guidance about how to act, if not under the ordinance, but just as a general rule to be an effective member of the board? Because I think going to Lee's point about where the ordinance is coming from and what's a conflict and what's appearance of a conflict, this is all about people having faith in the decisions that the boards make, and the further down the road that we can get, I think the better off we will be, that most people would agree. And then the only other add-on I would ask is, do you see any impact stemming from the fact that DRBs can have alternates? And should DRBs or bodies like that ever be asking themselves, well, do we want to try to have a board that is the most or least in any way involved in a decision, or should the use of alternates only be a function of they're not available, they're not in town, and we'll need to have the adequate number? Does that make sense? Because some boards might see having alternates as a opportunity to try to have a board that it's deemed the least somehow affected by an application. Or maybe that's prejudging things and they should just let the chips fall where they may. But back to Tom's point, is there any kind of rule for rules of procedure in this area?
You want
I can
to go first?
at least, yeah, do it. I mean, from what I can tell, the ordinance is an ethics and conflict of interest ordinance. So it's relevant, but I mean, for instance, the DRB is required to have, by Chapter 117 of Title 24, it's required to have rules of procedure as well as something. I think that's the separation, because the DRB is also supposed to have, its ordinance is also supposed to cover some of these issues in the ethics and conflict of interest ordinance. But this ordinance doesn't cover the procedure for the DRB in terms of, what's the order of a hearing, and the role of alternates, I believe, is covered in the DRB ordinance. So it's, I guess, we haven't, yes, the DRB rules of procedure. So I guess we haven't necessarily thought this through very clearly, and I think that would definitely be legal advice. But I do think there's still a role, because, one, it's required under Chapter 117 for DRBs. So the question is just how to play it out, and we haven't thought that through yet.
Mary, if you could please identify yourself and
My name is Mary Kehoe. I'm on the Development Review Board, and I just want to make perfectly clear, or I want to perfectly understand what was said earlier with respect to emails, because we are a judicial, quasi-judicial body. Our rules say that when a hearing is closed, we're deemed to be in deliberative session. And I know we're all really concerned about making sure we don't do anything that's violative of the open meeting law. But we also want to be able to fully deliberate and flesh out the issues that come in front of us. And sometimes it gets late, or sometimes we think the next day about something. So I want to be certain that I can send an email to the members of my board and not violate any open meeting rule, because so far I've been emailing only Annie monosyllabic emails like, yes, I'll be there. And I want to be sure that because it's something that's been a concern to us, and I think if I might be so bold as to speak for some of the other members of the board, we would like to deliberate a little bit more than sometimes time allows.
So the deliberations of a quasi-judicial board are not subject to the open meeting law.
So we can
As a
do it-
result,
Yeah.
you can deliberate by email exchange. But, and this is a big but, understand that those emails are probably discoverable. So you can use email without violating the open meeting law, but what you say in those emails could still potentially become the subject to could be just subject to disclosure in the context of litigation. But you won't violate the open meeting law by deliberating by email.
Okay. And then the only other question I had is the policy that I thought I would follow, being on this board with respect to conflict of interest, is when in doubt, bow out. Is that something that you all, being the well-versed municipal lawyers that you are, would recommend or not recommend, given that we do live in a small town? So the tension is there. In fact, it could be times when we have to call off a meeting if somebody can't be there and then there's a conflict of interest. So that's problematic because you want the wheels of government to turn. But on the other hand, being a very small community, everybody knows everybody else. I feel that way, and I've only lived here for a year and a half. So I would like some comment on that, just in terms of best practice, because the examples you've been giving are helpful, but they're very specific. So thank you.
Sure. Mary, first of all, let's be clear that, again, going back to deliberation, there's not a requirement that that the membership all be together in that process, so that you could potentially have deliberations of a subset and share the information with those who are missing before you make a decision. In terms of when in doubt, bow out, it sounds appropriate, but the level of information that causes you to doubt may not be the same level of information that causes someone else to doubt. So it's it potentially could be an overly strict or conservative application of good judgment. I think you have an ordinance that you can look to for guidance. You have prior to the ordinance, prior to the townwide ordinance, you had your own rules and policies that would lay out for you what is and is not a conflict. So there are sources from which you can draw some objective measurement of whether your doubt is well-founded or not. A knee-jerk, I'm not sure, so I'm going to take myself out of this, may be too drastic, and you may, in the effort to be good, be doing bad by eliminating from the board the capacity to make a decision. So I don't want you to leave here thinking anytime that it causes you to stop and think about it, that it's automatically the right thing to do is to recuse yourself.
Thank you. I was just more responding to Tom, which is, when in doubt, call up Bob, or when in doubt, bow out. So I bet you'll say bow out now, but...
I'll take your calls, man.
So what I mean is when you're really struggling with it. So, and it's a difficult issue for all of us. I'll point out that these 15 minutes have turned into an hour, so with the conflict of interest, and
Yep.
which I really appreciate all that work, but it is a struggle.
Tony?
I wanted to ask, again, addressing Tom's concern, if it would be possible for CBC members to also consult with the ethics board about issues, rather than, we know how busy you are, Gary, or is that the procedure it always has to go through the chairman of the select board?
I'm concerned about consulting with.
Repeat the question.
Oh, the question is, could a CBC member thinking of whether to recuse consult with the ethics board committee? And speaking for myself anyway, I think that would be inappropriate. If a complaint ever does get filed, we would have to make the decision based on all the information that comes at the hearing, and giving an advisory opinion would make that difficult. And in fact, the ordinance does not allow for the ethics committee to give advisory opinions.
Do we have any other questions? Would any of you like to make any closing comments on public records, open meetings, or conflict of interest? Let's talk about fence viewers.
Awesome.
All right.
Layers of coal.
I want to thank everyone for coming. We're trying to do this once a year. We have some municipal attorneys who have a lot of experience in this area. We're very fortunate to have a conflict, to have an ethics committee comprised of extremely strong members. If you have any suggestions to improve this, please let us know during this year so we can make it better next year. We want to make it better. So thank you for coming.